In 1972, New York State decided that there were too many bogus claims of injury arising out of car accidents. Hence, too many cases clogging up the courts. So, we entered the no-fault era. In that era, the New York State legislature passed a law that said unless you had what they considered to be a serious personal injury, you could not have a jury hear your case. Well, some injuries, in fact, are automatically considered by the courts to be serious. One of those injuries is the fracture. If you've sustained a fracture in a car accident, then you automatically have a right to have the amount of money that you're entitled to be decided by a jury. That right does not depend on the seriousness of the fracture. Even an undisplaced fracture, which requires no casting and frankly no significant medical treatment, qualifies for a jury trial in the state of New York. They do not automatically get a jury trial. If an insurance company's attorney can convince a court that these are not serious personal injuries, then no court compensation would be permitted. Well, it depends. A person who is hurt can't work for at least 3 months because of the injuries, then the court will frequently allow a jury trial. If a person who is hurt has an injury that continues to interfere with that person's daily life, then the court will also generally allow jury trial. Unfortunately, these distinctions are not necessarily very clear, or for that matter, even consistent between the various courtrooms and the various judges in New York. You should have a lawyer who understands the relatively confusing and frequently complex distinctions that judges draw when deciding who should and who should not have their cases decided by a jury. If you or a loved one have been involved in a car accident, contact the Greenberg Law Firm today.